All right, so session should be recording now. So we're not going to finish chapter 1 today. So I will have an assignment due next week, but it's probably going to be that South Carolina DOT versus the Granger. So I'll briefly talk about it once we finish the principles. Probably Monday we'll still be going over chapter 1. When I go over the principles today, there'll be key things that I want you to take away from the principles, because when the midterm comes, you'll have a midterm on principles and a midterm on definitions. And I'll have matching properties. So I'll have like properties, the principles on the left side, the right side I'll have the key terms, and you'll just match them up. So if we're talking about principle 1, if you see something about the Christians putting crosses in their boundary corners, or that the Greeks appoint Terminus, the god, to protect them, then you'll know that matches up. So I'll make sure that you know all the key terms as we go through this. Make sure, I think I sent some of you back an example of, if you don't want to type out all the principles, you can take a picture and bring it into your document. Did anybody see? I think I did it on yours. I don't know if you looked on yours. If you don't want to type them in, you want to do your summary underneath. The reason I like putting them together, because if you're trying to study for your principles and they're not on the same page, then you're having to go to your book and say, here's my quick summary. But if they're all on one, let me see if I can share my screen and put, I know I did it. I think I did it on yours, Jim. Click on there and see if you can see it. I know Paul typed the principle and then a quick description underneath. Monica, I know, did that. Dylan, you need yours. What didn't have both? You want to have both. So I did a picture. Yeah, I did yours, and then say, underneath is where you can match them up. That way, when you're studying, they're all on one sheet. You know how to share your screen? Like share your screen that we have with you. I don't want to log out. I was going to see if I could show his screen where I took a picture and brought it in. I mean, if somebody don't want to have to type them all out, what it is, I took a picture of the principles, brought that picture in, and then put summary below. That way they're all together when you're studying. I can send everybody a quick thing later on tonight as a group. Yeah, I was trying to figure out how I could share it. I know that you can somehow share your screen. All right, so let's go back to principles, and let's go back to principle 3, which is, I know we did at least through 4, but I want to talk about 3 real quick. There's a couple of things I want to get out of it that I didn't talk about on last Wednesday. So principle 3 begins on page 9. And it talks about a described closed boundary identifies a chain of right of any property interest for which any person can make a claim of possession through a claim of title. These boundaries will be either macro or micro in nature. So the surveyor needs to understand what the different classifications are. Is it a state boundary between other states? Is it between 2 counties? Is it an international boundary, or is it between subdivisions of nations? So we, as Or is it a boundary on a local level, such as a land grant or possibility of individual parcels of land? Usually, the original survey creates the boundaries of the land through actions and words in accordance to the law. Once an original boundary is created and described, the description remains in effect, legal, and forever. That's on page 10. Many other macro boundaries are disputed between countries and counties. Today, states of Connecticut and Rhode Island are disputing a common boundary that was created in the 1700s. Recently, what should have been a simple described line between Georgia and South Carolina was settled by the U.S. Supreme Court when it determined that the original definitive boundary, namely the center of the river, which was the center of the river, all the islands belonging to Georgia had been changed by estoppel. And I'll describe what estoppel is later on. I think that's in our part 2. So clients should expect surveyors to be expert measurers, collect the data. I'm on page 12, so I'm just highlighting some things. The work's not necessarily limited to land boundaries, but could include boundaries above the surface of the earth. In the event of a dispute, the surveyor's purpose becomes presenting these measurements and evidence of record to the court and the jury for their deliberation and consideration. Hence, their skills and knowledge of science and the measurement should be positive and should never be deficient. So, unlike other countries, surveyors in the United States do not have the authority to locate legal boundaries and that are binding on all parties. That's done with juries or judges. We just can actually, take the responsibility of interpreting the legal description, placing those descriptions on the ground, conducting surveys to recover evidence prior to work or surveys. In addition, then you could be called upon to do certain things. All right, back to that. So in North Carolina, so when we did a surveying conference here last September for Society of Surveyors. It's professional development. There is actually a unit in North Carolina that is in charge of like land disputes between boundaries, between counties, so like Harnett County and Cumberland County. So there's all kinds of things that they were doing. They said, they were talking about Cumberland County. They're like, I don't know why, but there was some discrepancy between Cumberland and Harnett that doesn't cost the county anything to go ahead and get this put on record, to go ahead and get it legally done, put on record, because there was some dispute. And he said, I don't know why. They said, well, do we have to? Well, no, you don't have to. It doesn't cost anything. Why wouldn't you go ahead and get this straightened out? It could be between somebody else's homeowners but he said they didn't want to. So the commissioners decided not to do that. But it is free. I'll look up and give y'all a link to but those guys came and they talked for an hour. So we had different presenters come. One was about title insurance, which is neat examples I can give you. One was how they determined where the boundaries went to. They said so this was one that's in charge of all the county boundaries in North Carolina. Like I said, it's free. They were saying they were trying to find a corner that was in a man's backyard, but the man was overseas for, I don't know, an extended period of time, so they had to get permission to go on his land or check to see it was okay. So that was kind of neat. Also, you may have to investigate people people from the past of what the intent was. So they said they were doing something, I think it was north of Raleigh, and they were trying to differentiate, between two counties, and they said that one of the guys that comes to the gas station every day, was like a little gas station that the community would go out and hang out in every morning, Said, well, the man comes every day between 11 and 12. Come between 11 and 12 and you could talk to him because he could probably tell you where that boundary actually was, where it originally was. So, I mean, they investigate all types of, because a lot of times it's going to be not only are you looking for stuff on the ground, you're looking for natural monuments, artificial monuments. What was the intent of all parties? So that was kind of neat hearing some of the stories and things that went through. Typically, if we have, I really enjoyed that one. It was actually a 8-hour, I think we got 7.5 hours of professional development, but with the coronavirus, we weren't able to do it this year, but you as students would be able to sit into those type. Y'all were able to sit into that one last year. And it was pretty interesting. You know, it was only like an hour per topic. So somebody new would come in. The board attorney came in, so that was great to hear, you know, his take on things. Title insurance guy came in and talked. He could have talked for 2 hours. He had us all kinds of examples, which I have. He made copies of the examples. The guys that talked about that are determined for disputes between counties, they came in, you know, talked about their information and what, you know, how they derived it, figuring out what the conflicts are. So that would be micro and macro. So this would be something they're interested in. The next thing would be principle 4. So principle 4 is a person or landowner can legally convey only the quality and quantity of interest in land that he or she has title to. All right, let me first off say this covers from chapter, it goes from page 13 all the way over to 21, and then it talks about it again under 21. They wrote principle 4 again under 21, and it goes all the way to 23. So it's a long one, but if I was going to try to sum it up in a brief sentence, I'm going to say this principle covers the rights of ownerships and the difference between estates. So there's your key word for principle 4. Now, what does all this mean? So starting on page.
What did you say the key word was?
Principle covers the right of ownership.
Oh, okay.
And the difference between the states.
The difference between the states. And so I'm going to kind of give some examples of this. So a surveyor is the one who creates the boundary lines, creating nothing but an invisible line that is described by numbers, yet no line can exist without the endpoints or the corners. So I think that was one of the questions I gave you. So when we're putting in property corners, we'll put in the endpoints. You know, if it changes direction, we'll put endpoints. It's a mathematically, or it's an invisible line. So putting in the endpoints. We're going to be talking about rights and interest in land. And that's on page 16. And we're going to talk about bundle rights. So rights and ownership are related but not the same. When a person owns a parcel, usually that person has the rights to timber, water, minerals, and the possession. So not so much around here, but up north or Texas, if you sell the land, you may keep the oil rights or mineral rights. Let's say if they find oil later on, some people would exclude that from when they're selling the land. So, yeah, they will. I've had people ask, you know, they came here and they're like, can we exclude this from it? Well, we typically don't, but yeah. I mean, if somebody wants to buy it, and they can keep the mineral rights for themselves. So if oil's found later on that land, they have the rights to it. Whoever bought the property, because the original owner kept the rights. So title is the means or vehicle usually documented by which one acquires the estate. Rights, such as the right to take minerals, are attributed to a person, may be held by a landowner. A person holding a lien on land may have interest but not a title, depending on the respective state where the property is situated. Interest and title are not synonymous. Let's say I did the surveying on your property, and you wanted, and we were going to subdivide, I was going to do a 10-acre survey, going to subdivide it in half, 2 5-acre tracts, but you didn't pay me. So I could have an interest, I could put a lien on that land, and before you sold it, you would have to pay me. So a lien would be, so in other words, I would have interest in it, but not the title to it. So is that kind of, so I could put a lien against it. And now I was telling you that some of the builders, before they sell the houses, the attorneys are having everybody that performed any work to sign off that they've been paid before they can sell the house. Meaning, has the building supply company been paid? Has the plumber been paid? Has the heat and air guy been paid? Because if somebody puts a lien against the property, it's going to be whoever owns it at this point. So I guess that happened too many times to where a lot of them they'll ask you, did the surveyor get paid? So I have seen that where they, have a list and everybody has to sign off before, they can sell it, because you don't want it to go on the new homeowner. So whatever the rights or interests a person may have in the land today are controlled by and regulated by laws of the state in which the land is located. So although no law school lists the specific rights that attach to a person's land exist, certain common law rights are recognized. So the right to dispose of your property, that's not inconsistent law. A right to have land free from interference. The right to support of the property, both subjacent and laterally. The right to use the water that flows to property. So even though there aren't such, in law, there are certain common law rights that we recognize. How they get you is zoning a lot of times. So you have the right to do what you want with your own property. But the minute you put a building up and you put it too close to the lot line, what they gonna say? You're violating the ordinance, or you're violating the zoning. So that's kind of how that's how the local or state gets you. Usually zone in or an ordinance, not so much you should be able to do what you want to do with your own property by law.
Because there's a lot of people got to fight their water rights.
Yes. So these rights are identified very early in English law. So they're bundle rights, and they usually extend from the center of the earth to the accolades of the heavens. Such of these rights include, but were not limited to, timber rights, air rights, mineral rights, and the right of possession, water rights, and right of ingress, egress, and regress. So each right may be independent of the exterior boundary of the parcel and may have boundary lines that are separate but distinct and independent of the exterior boundary. I'll show you all a plat on that in just a second. A landowner may ultimately convey numerous rights, and the surveyor may ultimately survey numerous boundaries within a parent parcel. Some property that I've looked at, it for the plats, there's easements for drainage. There's an easement for utility, which would be PWC. The drainage would be PWC. Just water and sewer would be PWC. So there's several different easements on one piece of land, but it's all one piece of land. So it's held together by one boundary. So when we were looking at the knolls on Cliffdale, we had a 20-foot drainage easement, which was left and right. Typically, the city would maintain that. But then they're trying to get away from maintaining and say after, let's say, 20 feet off the edge of pavement, it's the property owner's right to keep that clear. We're not gonna get involved. The reason they were trying to do that is because they said in Fairfield Farms, I'm pretty sure that's subdivision, that people were putting up sandbags and were then blocking the natural drainage easements and were causing places and houses to flood. So when another subdivision, they started seeing people putting fences up in the drainage easement, they sent the owner of, or the developer, a certified letter saying they will no longer give them any additional building permits in the subdivision until everybody's in compliance with removing stuff out of the drainage easements. Yeah, but here's what the owner said. I sold that lot to a developer. What the developer said, I sold it to, let's say, H&H Homes. H&H Homes built the house, sold it to a homeowner, and that homeowner put their own fence up. I'm not responsible for what happens, 3,
4 years down.
yeah, 4 years down the road. We used to do what they call a closing map that shows what you're buying, if there's any encroachments, if there's any easements. We do a surveyor's report that tells you don't put anything in these easements because it's going to be, it might be to your, not to your benefit if it has to be moved. I mean, it'll tell you, at your own risk. You definitely don't want to put in those overhead power line easements because they got to get there and maintain that. If not, I think they came out with the solution was put a gate and we'll let you keep your fences up. But that one area off Lakewood and Fisher, that whole area had a huge drainage, and I was telling you, it was in it, people's fences were in it. Typically, we tell them, I mean, but you own the property, you're paying taxes on the property. So we tell you not to put something in there, it possibly could come down if they have to get in there. The good thing about utilities, like it's PWC, water and sewer, usually they're underneath. Typically, especially sewer, they can clean it from the manhole, so they're not going to have to disturb if you have a driveway in the easement. They may have, Mr. Rainey says they have something you can sign off on, but they'll let you keep your driveway in the easement. County will let you put your driveway in one of their easements. So some of these, when you don't have it about 10 feet left over to put a driveway in, something's got to give. Or maybe that wasn't a good design on the surveyor's part to have two easements coming down, one on each side of the property line that went to 2 different entities and trying to figure out where to put a driveway. So that's kind of things to keep in mind. Again, we're just going to be talking about principles, and we're going to give our opinion, and all our opinions could be a little different. When I took the first part of the surveying exam, there was some opinionated questions on there. Like, what if a homeowner, what if, a client came to you and wanted you to survey, let's say, Federal-Tex property, but they didn't own it. What would you do? Well, we could survey, maybe they're going to buy it. But if we actually have certain counties make the homeowner sign off that hey, I dedicated this. Some counties don't require the homeowner to sign it and then sign off on and have it notarized. Because what was happening here is Cumberland County said they were getting too many people hollering at them because the surveyor recorded something that they did not approve. So now Cumberland County, whoever the homeowner, has to notarize, yes, this is, my intent, free will, But so when we're looking at our intent, my intent, your intent, we could look at, like I was telling y'all, we could look at the same scenario in two different surveyors come up with two different possible solutions. You want to give as many solutions as you can, because court's going to be the one that are going to base their opinion off who presented the best case. So that's kind of what we'll talk about. So back under page 18, when we're talking about estates, and these are still under bundle rights. So it says estates differ primarily in the length of time which they may exist. So an estate may be either absolute or conditional. In many instances, fee simple denotes absolute. So a fee simple estate is the highest, greatest estate in land that one can attain. Because fee simple or absolute means it's for all purposes, the owner of the land. In other words, for all purposes, the word fee simple absolute is in reality are not a single term. For each word creates a meaning that explains the entire term. Fee denotes that the estate is one that can be inherited or divided by a will or other document. Simple denotes the estate is not a fee tale, whether the estate must be inherited by a specific person. And then absolute means that there are no conditions or limitations so far as time is concerned on this estate, and that this estate may continue forever, not likely in a fee or an estate that may be determined upon the happening of a future event. So if somebody gets the fee simple estate, it's usually one person and there's no limitations. So sometimes estates that leave it to several people. So fee simple estate is the highest form, and that's because it's one person and there's no regulations or no conditions. If it's fee tail or estate tail, it's limited by the grantor to the heirs or the grantee body or a special class of people, either female or male, or it could be like the oldest, the youngest, or other. So they could put it, could put restrictions on that. So there is some type of restriction on that. A life estate is considered a freehold estate because it can be conveyed to a third party, yet duration is measured by someone's life. Essentially, the life estate lasts only for the life of some person. I will give y'all a good example of that one. All right, my parents had a home. It's paid for outright. My mom passed away. My dad's remarried. So when he got remarried, they had to decide whose house were they going to live in. Were they going to live in hers, or were they going to live in his? So they decided to live in his. So his new wife has a life estate, so she can stay in that house as long as she's alive and that she wants to, because you don't want, if she's making it a home, we don't want to kick her out as soon as my dad dies, because they're trying to make it a home for them both. But once she either leaves it or passes away, then it goes to my brothers and sisters and me. So that would be, a estate. A lot of times people will go ahead and put it like my dad would have got it 10 years before, he passes away. You could put it in an estate and then give him lifetime rights to stay there. So a lot of times people do that just so that it doesn't go, and I'll give you an example of where that benefits. My dad's mom, my grandma, had a house. And when she got put in a nursing home, then the house that she was in had to be rented out. There was a certain cap that they could make for it. Once she passed away, that house had to be sold at auction to pay back her bill for the Medicare and for where she had, where they had taken care of her so many years. So it had to be sold at estate for that. So if they would have got it out of her name way before that, let's say 10 years before we were having to go into a nursing home and all that, they probably could have saved it from having to be sold at auction. So that's just kind of an example, a couple of examples of, where this would fit at in real life. So,
How do you know which estate you got?
what do you mean? Question, what'd you say, Thomas?
Is there like a spot that tells you what type of estate it is? Or is it just kind of known?
You mean like how would I know she had a lifetime?
Yeah.
They would have to draw up a document. There would be a document on record saying she has lifetime rights to it.
Would that be part of the deed?
Yes.
Oh,
In the 18, it's not their original deed, but it'd be something, like they had a will drawn up, so it was in the will, not the original deed. The original deed's still to both of my parents. Like I said, my mom passed away about 5 years ago. So life estate would be something usually, attorney's gonna have to write it up.
Is it a deed or in the title?
It's usually a will, like a will. An attorney will write up a will, and in that will would say they would have lifetime estates. You could set up an estate, but an attorney would have to set your estate up as well. Typically, they won't do a deed to say, hey, this property, she keeps it for such and such time, and then it reverts back to the owner. Typically, you'll do that in your will. So wills are different. We can't go pull up wills, but you can get the wills from down at the courthouse. You just have to go in and, we've done this before. Y'all know how to look up deeds online. But if it's a will or something that we don't have access to, they have the books on record, and you can, each year when things got sold for that whole year, you can look at the last name and go to it and find it. And then you can ask for the will for them to pull the will and get you a copy. It takes a little while, but if y'all had to do that,
Yeah.
it's process.
Normally just goes to the deed listed before the will book, but in some cases, that's all there is.
That's right.
And that gets to be a thing. A lot of times they don't have it.
All right, so just to give you kind of some ideas of, and real examples, I had to pull a will up for something because it may not have been on a recorded deed of how you acquired the land. You might not have acquired, you might have got it by will, like somebody passed away, they get re-record a deed. All right, still under principle 4, real property and personal property. And I'm going into this is going to be this is at the bottom of this chapter 1 you're doing. Real property is fixed, immovable, and permanent. Personal property is consumable, can be destroyed, or is movable at will. If I'm wanting you to give me the definition of real property, if you just say fixed, immovable, and permanent, I'll know what you mean. Personal would be consumable, can be destroyed, or movable at will. The distinction between the two may not be clear, yet it must be made. So standing timber, in reality, cut logs may or may not be personal, but a surveyor's failure to report cut logs observed in hot or cold decks in the course of a survey may result in a liability if the client suffers damages by the surveyor's failure to do so. Crops are considered personal, but title may pass with the land. Perennial shrubs are real, but nursery stock is not. Tree seedlings in beds are personal, but the exact same seedlings planted are real. Fence posts in a pile are personal, but the same fence post in the ground may be real. A surveyor's failure to, identify those pine seedlings in the healing beds behind a barn resulted in the client being sued for a large sum of money because the seedlings were considered as real by the leaser or the vendor. So the actual determination of the classification rests on fact or evidence, not necessarily law. Now, I've noticed a lot of times you can't go out and locate every single tree on a person's land. We do any improvements we do. And we might just do like a little area called shrubs. Or I noticed that like on some of the plats, they'll have the tree line, but they could be all wooded. I mean, just completely wooded. Be a variety of trees, maybe put wood line. I know when we were doing something in Hope Mills, they want us to locate every tree of a certain diameter. I was like, well, we'd be there all day long. It is heavily wooded. I mean, that's just, that doesn't even make good sense that we'd be here for days. You're not helping. Why don't we just put this as heavily wooded, da, 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 da. And I think, it worked out with the planning board, they come up, and that was in Hope Mills wanted us to locate every tree a certain size or diameter, but it was all wooded. There wasn't nothing, it was all wooded. So you want to locate any improvements, especially where they cross a line. In Surrey 3, we go into more detailed on that. We'll actually look at any utilities that cross, what's under the ground. How are you going to know what's underneath the ground? Who was it? They said they were waiting on 811 to locate somebody. Wasn't that somebody in this class?
You see? Or
811, where you can call for the underground utility. Yeah, they'll even for you to survey, they can locate them for you. They used to not like to do that, and they would say it had to be prior to construction, but now they are, because if we can find out where the utilities are, then we can try to get input. I would definitely take pictures of everything, like if you locates are called in, I would definitely take pictures because I have seen it. We were doing, down Riley Road they were putting water along the right side, coming out to Old Grayford Road, and when they went to put the bore on, we took all the pictures of everything ahead of time. There was no, and then of course when they go to do the construction, they call it in again to update it. They didn't mark a telephone, never was marked, had no idea. They actually hit it when they put the bore in because they were boring. They weren't open cutting it. And when they did, it cut the telephone. Well, telephone company wanted $5,000. You got my, unless the microphone might be on. So they wanted $5,000 for them to repair it. So I'm not sure what ended up with that, but we had pictures showing that none of that was on there. And the locates, who pays for the locates?
We do. Taxes?
No, your utility companies do. Mm-hmm. So utilities like PWC,
They get tax money too.
telephone, cable, fiber optics. So usually the utility companies pay for that. So you want to make sure. So we're still under principle. Okay. And that's why I did not go over this. So I'm going to talk about this. I did not go over this Monday or last Wednesday. So title to land, and I probably aren't going to have much more time, does not constitute real property. Title in real property law is the right or means by which one claims just or a legal possession of a parcel of land. In the true sense, to determine the boundaries, the surveyor generally uses the same documents as the attorney used in aspect and comment on the title. So a deed could be your title. So what they use to transfer ownership, we'll take that deed and put it in on the land put it in using CAD and try to find what's on the ground. Land in the solid material of the earth, soils, rock, clay, sand, lava materials, and so on. Real property has become synonymous with land. But now they're saying it's 4-dimensional. The average surveyor, attorney, and court thinks of real property or land as only 2-dimensional, like length and width. Yet, there is the third, including a height, so a depth. And then now they're talking about time.
Oh, that's the fourth, huh?
Time's the fourth. Third element would be depth, like surface, interpreted like below, above, like minerals, water, passage, aerial rights, space above the land itself. But time now is the 4th dimension. So for how long you've had something. English common law and the courts in the United States also recognize a 4th dimension, time. Time can be described or indicated the duration of the legal right to real property that a vendor has to convey. So with the event of high-rise condominiums, parties bought and used rights to airspace within rooms. At the time, surveyors have been asked to define, locate, and describe certain air rights in relation to signs, elevated walks, scenic or visual parameters. In ancient law, underground waters were considered as part of the soil itself, thus ownership was in the name of the surface owner. Some states have legislatively separated water rights from the bundle rights and treat those in different manners. To a point that a fee simple deed is drafted, water rights are not included in the conveyance and separate deed is required to convey water. So with respects to ownership of lands, adjoining tidal waters, lakes and rivers, riparian rights would attach to the land. However, the nature of the riparian rights is still being determined by our courts. So I think, Monica, I saw something you had about the 4-dimensional on one of your questions when you had submitted, talked about 4-dimensional, which is, we think of length and width, but we don't think of under the ground, the depth, and then we don't think about above or time, how long somebody's owned something. Any questions? So basically, now when they're doing condominiums, they'll do like a plat for condominiums. But what if you were trying to write up a legal description before plats, or because they used to not require. Since '84, we're required if we subdivide anything to do a recorded map. But there are condominiums. So they might label them like 1, 2, 3, 4, A, B, C, D, and then you bought all of that unit and just hope you're in the right area. But what if it's before that and they were, they've had high rises and things way before. So you're called upon to try to hope that you've got the right space. What if you bought a house across the street from the beach and you should have scenic rights, or you have some type of rights to the ocean, and somebody comes in and puts a big high-rise condominium in front of you, could you sue them?
Yes.
Yes, you would.
I think I've seen something where the,
But I will tell you about
Yes.
the couple who lived there for 25 and 30 years. Somebody behind them, looking, the scenes over here, they sued this couple that lived there for so many years because their trees were too tall and it blocked their view of the scene. And the courts went with these guys and made this couple cut the trees down because it was blocking the view.
and it might have been from the mountains, or it could be from, so there's scenic
Which is
views.
crazy. Must have been California.
Must be.
That is great.
So I remember you telling me that, showed me that last year, and I thought that was a neat thing, because so we're just gonna be touching on, I'll try to bring real life situations in here, so you'll kind of make a little more sense than just reading this, because it's very bland and dull and can put us to sleep. So we're not definitely gonna finish with this week, because I hadn't even got through 5. And 5, I'll go ahead and tell you this, 5, 6, and 7 sound all the same to me. Even though I did break them down, they used to have them combined. I think 5 and 6 were the same, and then 7 was different. Now they've got 5, 6, and 7, so I'll kind of pick up with that. Because this just talks about if there's not federal law,
State law.
then, state law will be what governs. I'll try to get some maybe examples. There are a couple that were some examples, but I'll try to get some examples for you. So I'm not quite ready for the Granger versus South Carolina DOT, because what I'm going to want you to do on that particular one is to kind of look at all the principles we've talked about. We haven't only talked about 4 principles really, and find out based off this who you think should own, that land. But I haven't divulged everything about the chapter. So you're really going to have a buy this week as long as you get your chapter 1, part 2 in, you'll have a buy this week. And then once I finish, probably Monday, we'll finish going over the principles. I'll describe, what's entailed with the Granger versus South Carolina DOT. Any questions? Okay, so I can stop recording.